Looks like the parties are ready. We're here today now for this afternoon, Ruiz versus State of Iowa. Ms. Donels, are you ready? You may proceed.
May it please the court, Mr. Sloven. Hello again, Your Honors. Good to see you again. Thanks for inviting me twice in 1 week. As you know, my name is Jess Donels, and I'm here on behalf of Brandon Ruiz. I suspect that the reason we're here today is because Mr. Ruiz is the latest victim of the indigent defense crisis. Mr. Ruiz was structurally denied counsel in a second PCR petition. The case was dismissed, and now we're here. The traditional solution when counsel is structurally denied is to remand so that he has the opportunity to have the effective assistance of counsel in resolving his PCR petition. But that's really not good enough with the circumstances confronting the court in indigent defense at this point in time.
But you're acting as if that structural thing is a given. Persuade me that that's structural.
Absolutely. So Mr. Ruiz filed his second PCR petition, and counsel was appointed, Ms. Agnes Warretier. The same day that the state filed a motion to dismiss for statute of limitations violation, Ms. Warretier filed a motion to withdraw, citing workload. That motion to withdraw was not ruled on for 6 weeks, at which point the court ruled on it, saying it was not possible for her to withdraw because there were no other court-appointed attorneys accepting PCRs in Scott County.
You're talking PCR 2. I think you have to talk about PCR 1 as well. PCR 1 occurred, and there was a hearing on the merits, and it was appealed and affirmed by the Court of Appeals, right?
But we can look at that a little bit closer. The first PCR was filed on January 22nd, 2020, which was about 6 weeks after direct appeal concluded. It languished for 2 years with no action. Counsel was appointed and ordered to file an amended PCR petition, and that amended PCR petition was not filed until February 1st of 2022. That's 2 years of the statute of limitations gone for no real clear reason. Now, there was a hearing on the merits at that point, and Mr. Ruiz lost. On appeal from the second PCR, appeal counsel raised a single issue related to trial counsel's argument in closing arguments at his trial. That issue was not preserved. It was pretty clearly not preserved. The sole issue raised on the first PCR appeal was an issue that was not preserved. There were about 6 issues raised during that first PCR. The sole issue raised was not preserved.
What's the stopping point?
That's an excellent question. I think Allison started off on the right foot by saying that this applies to a second PCR. It can't go on forever and ever. The equitable tolling rules also are pretty...
I mean, you're making an argument that there's constitutional implications. Why isn't it just turtles all the way down forever? And, you know, you have a third PCR for the ineffectiveness of the second, which was related to the ineffectiveness of the first, and we just keep going. I mean, maybe you want that. I don't know. But I guess I don't see why it has to stop at 2 unless it's just an arbitrary line drawing exercise. And if that's the case, then why isn't the legislature's 3-year line sufficient?
I don't think the 3-year line by itself is the problem. I think excluding claims of ineffective assistance of first PCR counsel was the problem. And the federal courts deal with this too. That's why ADPA was passed to limit successive habeas corpus applications in the federal context. But
don't they hold that ineffective assistance of counsel isn't cause? I mean, they have a good cause escape hatch, but they're rejecting the argument that you're advancing for exactly this reason. Otherwise, it is just turtles all the way down.
If I'm understanding your question correctly, there is no claim in federal court. So if you file a federal habeas corpus petition for your federal conviction, a 2255 petition, you can't then bring a claim of ineffective assistance of 2255 counsel. That's foreclosed by statute. That's foreclosed by the case law. That has not been foreclosed in Iowa. In Allison, this court recognized that there was an effective right to assistance in PCR counsel. It was a statutory right. That's something that's...
it stops at, at least the Lato, your Lato right, because this is really, I know the Court of Appeals didn't talk about it, but this is really a Lato situation. What happened below here is just a counsel who just completely dropped the ball. The difference being that Lato was the first PCR, and you, especially now that Iowa says you can't raise ineffective assistance of counsel until you get to PCR. I can see the argument that you ought to have a right to a lawyer in your first PCR, a functioning lawyer, and it's structural error if you don't get one. In other words, I see Lato for the first PCR. For the second, isn't that maybe a step too far?
I think so. The court was invited to reach that conclusion in Allison, and it resisted that, to quote the decision, smooth as ice conclusion that there is no effective right to counsel in PCR.
Allison has been, I think the legislature's done some work in that area since Allison and tried to, tamp down on it to some extent. I mean, even in the federal system, when you're talking about federal review of a state conviction, in Martinez, they will cut you slack on the first PCR too, but for that very reason. But then once it's another PCR, that's no longer considered cause for failure to raise an issue, failure to preserve an issue before ineffective assistance. So in a sense, they stop the ineffective assistance argument at the first PCR as well. I mean, why isn't that a reasonable line?
Because it's inconsistent with what this court has recognized in Dybel and in Allison, that if there's no right to effective assistance of counsel in PCR, then the right to effective assistance of counsel at trial is also meaningless. And I think that's even more true when you look at the fact that we can't raise ineffective assistance of counsel claims on direct appeal anymore. So if there's no effective assistance of PCR counsel, there's no way to challenge the conviction at all.
It's cause to raise, you can raise ineffective assistance of the first PCR counsel. But here, still what we're talking about is a structural error where second PCR counsel dropped the ball. And so you're really almost arguing ineffective assistance of second PCR counsel, right?
It's really tempting to look at that first PCR and say, was there an ineffective assistance of first post-conviction relief counsel claim that Ms. Ward-Tier could have made? But that would be looking into an alternate universe that didn't exist because she did nothing. There's no requirement to prove prejudice in a structural denial of counsel because there's nothing in the record to tell us what she did or did not do. Prejudice is presumed. And this is true in federal cases where a defendant asks for an appeal and no appeal is filed. Even when they got the mandatory minimum sentence, even when there was an appeal waiver in their plea deal, it's still a structural denial of counsel not to file that appeal, even when it's 100% obvious that there's no prejudice, because their right to counsel was denied. Their right to file that appeal was denied.
In the first PCR, there was eventually a hearing on the merits, and it was denied, and the Court of Appeals affirmed. And the new PCR2 had no new facts alleged, right?
Mr. Ruiz checked the form when he filled it out pro se, saying that there were new facts. He didn't
Alleged.
explain what they were in his PCR uncounseled court filing.
Reporting of PCR2, correct?
There was an unreported hearing. I believe that the judge's order suggested that the only thing that happened at the hearing was that they requested time to file a written resistance. I have no reason to believe that the judge would fail to describe argument that took place. The implication to me reading the order is that there was no argument. They asked to submit written arguments.
But there's no evidence on the record that counsel made no arguments. There's just, I mean, you're assuming there was nothing said because the judge didn't report it?
The judge would have said, I have considered the arguments raised by Ms. Ward-Tier or Mr. Ruiz.
You're assuming that one, right?
She ruled in the absence of any resistance.
He's well represented. Let's say you got a do-over. What ground for relief is there on the merits that would entitle him to a new trial?
I appreciate that. There are options. There are safety valves built into the statute of limitations for new evidence or new ground of law. I can't,
Those in his case.
because it's not in the record. All we have is what he put on the form, which is that there was new evidence. We also have the issue that he says first PCR counsel was ineffective, and I can see the argument. That is in the record. I think raising as your sole issue an issue that obviously wasn't preserved is a strong basis for arguing ineffective assistance of counsel. So his first PCR didn't even make it through one full round of review because it wasn't presented on appeal. So, but we're delving into an alternate universe that doesn't exist, one where Ms. Warutier would have made these arguments.
Isn't an exercise in futility if he, in fact, he doesn't have any winning argument.
Winning argument, Ms. Warutier still had options. If she had investigated the case and found out that all of the claims were frivolous, she could have filed an Anders brief and asked to withdraw. That's not what she did. She remained silent. She offered no resistance.
You're arguing for using Lado for structural error, but there's some significant differences between Lado and Ruiz, and one of the things we haven't talked about yet is in Lado, the district court dismissed the first PCR for a procedural rule, 1.944, whereas in Ruiz, it was dismissed, the second one, because time barred by statute, 822.3. Do you see any distinction between those two as being supporting or not supporting your position?
A distinction, but I don't think it makes a difference in my position because there were still arguments to be made below. There's another case cited in the record, I believe it's Mayorga, where the structural error was failure to attend a hearing on a motion to dismiss, and a motion to continue was filed and the party didn't show up for the hearing, and that was a structural denial of counsel. There was one more in the record where I mean to interrupt you, Jeff.
Included, I think, a more egregious case where the district court judge warned counsel, hey, your case is up for 1.944. The person appeared but filed nothing, never requested any relief from 1.944, which does provide some unique escape valves as opposed to the other statute. The statute does not have as many graces that can be given by the court. So I don't think necessarily it's an easy connection, dots you can connect that it's got to be structural error because it was in Lado. In this case, she did show up for trial. Did she file a lot of stuff before, or did she actually use her opportunity for a brief? No. But how do you know she didn't file a brief because maybe she didn't want to enunciate things? We don't know. There's no evidence. There's no record. So I think that's different than specifically being ordered by a judge, do this, and you're up for dismissal.
Notice that it would be dismissed because the state filed a dismissal, and our Iowa's rules require you to resist things that you don't want to happen to your cases. So it's not quite as clear-cut maybe as the procedural dismissal for failure to prosecute, but it was pretty clear what was going to happen in the absence of a resistance. And again, if she had done the research and found that there was no escape valve available in this case, that's what the Anders brief proceeding is for, so that counsel can protect their duty of candor to the court without unfairly undermining their client's position. She also could have asked that Mr. Ruiz be allowed to present his arguments himself. He couldn't do that under the current rules because courts are not allowed to consider pro se filings by represented litigants. So by being on the case and doing nothing, she also prevented Ruiz from presenting his own arguments to the court.
You make a point about that basically the first PCR wasn't too long. Too much time was spent on that. Have we held before that that is ineffective assistance, or for the second PCR to not raise that?
I think this rolls right into the equitable tolling argument that I briefed, and that's because that was a circumstance that was beyond Ruiz's control that led to the statute of limitations expiring. if Ruiz's first case had not lain completely dormant for 2 years, by the time the amended complaint was done, it went to trial in a matter of months. He could have timely filed a second PCR claiming that first PCR counsel is ineffective. And that's the problem. That's the safety valve that we need to address. I see my time's about to expire. Unless there's any further questions, I'll see you in about 15 minutes.
I think I'll be lucky if I get out of here in 15 minutes. May it please the court. Counsel, good afternoon. It's a privilege to be here. I think that we have to talk about Lato after Smith v. State, because Smith correctly explained what is and isn't structural error.
Really disagree with that. I mean, Smith is just summarizing a federal case, and whatever it says there is not, it doesn't do any work in that particular decision. And in Sothman, in 2021, we actually reaffirmed Lato and listed those specific instances where we find structural error, and that included the Lato situation again. So we reaffirmed Lato in 2021. You know, I really disagree with that. You didn't even talk about Lato in your brief, did you?
It really isn't applicable to these facts, and I'll explain why. The Chief Justice basically hit it on the head. But I think you have it backwards, which Sothman and Smith, which one of them is dicta as applied to this case and which one has a holding. In Smith, it's a holding because it explains why the Court of Appeals was wrong to apply structural error in that case to a ineffective assistance claim not preserved. Smith explains that structural error means it's a class of error where if it is preserved and then renewed on direct appeal, automatic prejudice, either because we can't assess the impact or because it protects a different interest other than the fairness of the trial, or because it so fundamentally infects the prosecution itself with unfairness.
Right, but I'm not, you know, we can argue about what's dicta and what isn't. I'm actually working on an article, I think, on that subject. But, you know, the point is, under any definition of structural error, what happened with the jury strikes in Smith wouldn't have been structural error. So this, what you're referring to is sort of a broad statement of what is structural error under a U.S. Supreme Court decision citing federal law. Sothman and Lato go more specifically to what we have found to be structural error in the context of our analysis within our court. And that's why I think they're more important.
I'd suggest that Smith shows why that term is being misapplied in the context of Lato. Now, I don't think you necessarily need to overrule Lato. I think what you need to do in this case in particular is to recognize the holding and limits of Lato and its logic. Lato is a case about a breach of duty that became the grounds for dismissal. Because of what counsel did in not prosecuting the case, in not resisting the 1.944 dismissal, because of that, it was dismissed. If not for the breach, no dismissal. Now, I think it'd be more correct than calling that structural error to say, we've identified a particularized breach, and here's a showing of how it affected the result. And you can say, in those situations, we don't look any further, we don't look at the merits of the claims, we just say that's enough of a showing of prejudice that but for the breach, or the breach is the grounds for dismissal, but for the breach, that grounds for dismissal doesn't exist. Same in Villa Magana, exact same situation. And the same in Mayorga as well.
Was a 1944 dismissal. So the breach caused the dismissal. If the lawyer would have filed anything.
Right, exactly. And it's a very clear link between the breach and the alleged, the asserted prejudice.
Now I'm following your argument. Yeah, so you're saying, instead of saying there is no possible structural error when the counsel doesn't do anything, you're saying here they actually had an affirmative obligation to show something to get beyond the 3-year statute, and they didn't do that, and that's in effect why they were dismissed. Not that this 1.944 deadline.
1.944 wouldn't be the only time if you state this principle more generally. Mayorga, counsel doesn't show up for trial on the PCR application, and the court just says, applicant has the burden, trial wasn't continued, the case is dismissed. But for the breach, not showing up, the grounds for dismissal aren't there, right? Same application of the rule. Now, I would say that one advantage of doing it like this and moving past the term structural error is you don't get all these Court of Appeals opinions saying, well, is this level of involvement by counsel enough to be complete non-involvement, or is this representation to a point that gets you past structural error? This approach that I'm talking about actually identifies a breach and tries to find prejudice flowing from that breach. And if there isn't any, then, and it's most appropriate because A, structural error is generally only recognized in an actual criminal prosecution. B, structural error has to be preserved generally, or at least the way the term is used. If you're finding that this doesn't describe the thing in Lato, good. Then you shouldn't use that term to describe it, and it'll be a lot clearer for everybody. What I want to say about this case in particular, first, is that we don't know what happened at the hearing on the state's motion to dismiss. Counsel is telling you that that PCR counsel didn't make any arguments, didn't let Mr. Ruiz speak, none of this is supported by the record. And in fact, the PCR ruling says that exactly what she told you it would say if counsel did make arguments at the motion to dismiss hearing. It says, having considered the arguments of counsel and the applicable law, and then it grants the motion to dismiss. So this kind of highlights the fact that if you're going to allege something like a complete deprivation of counsel, something that would be analogous to structural error almost if that existed in this context, you would need to affirmatively show that counsel didn't do anything. And in this context, that would mean filing a 6.806, creating a record of what happened at the hearing on the motion to dismiss, and establishing that no argument was made. But the most important thing I want to say about this ruling is the basis for dismissal is the untimeliness of the claims, not any particular breach of counsel. The PCR court considers the claims and the motion to dismiss, applies the law, and says, these are time barred. That is, you can picture effective assistance of counsel that would produce the exact same result because these claims are time barred. Ms. Donels said that Mr. Ruiz checked a box that said that he had new evidence. He didn't actually say that. He said there exists evidence of material facts not previously presented and heard. And then when he specifically explained what he meant, the first two claims are just ineffective assistance of PCR counsel in the first PCR, and then the third is actual innocence. There's no, and then when he says what evidence supports that, it's all public record, the Iowa Court of Appeals opinion, all things that not only existed during the first PCR, but just can't possibly be new. So I think that, it's very difficult to look at this case and identify a meritorious argument that counsel should have made that would have prevented dismissal. I think that's all I need to say on that. This case is more like Dunbar when you think about it. In Dunbar, their PCR counsel submitted the PCR application on the existing record, and then Dunbar goes through and he makes a series of ineffective assistance of PCR counsel claims about things that PCR counsel could have done differently, presented more evidence, made more of an argument, right? And Dunbar goes through and analyzes them piece by piece and says he has to show prejudice for these. And in the absence of a record that can do that, there's no basis for granting this claim. And I think that's analogous here where counsel was appointed. There does appear to be counsel's participation in the case. There was never any preserved challenge, no registered complaint with the district court from Mr. Ruiz about the quality of his representation or any sort of, failure to communicate or anything like that. I think that matters a lot, especially if you're going to use the term structural error, as Smith points out. That needs to be preserved in some way. It needs to be brought to the attention of the district court so it has an opportunity to either grant relief or err by not granting relief. That not only ensures that you get a ruling, it also guards against a waste of scarce judicial resources, and it promotes finality interests.
Structural error is you don't have to preserve error below, right?
Not exactly true. That is the way that structural error works, from my understanding and from my reading of Smith, is it is a class of errors that defies a prejudice analysis. And so, when preserved and then raised on direct appeal, you get automatic reversal.
Talk about Smith, but we have Lato out there, and we have other cases that have talked about it and reaffirmed it. So, so you're saying, at least we can distinguish Lato on these various grounds that you've offered. Is that what you're saying?
Highlight something else that was already mentioned is that Lato, Villamagana, even Mayorga, all first PCRs. That is the procedural context where there may be a due process right to counsel to present claims related to the effectiveness of the assistance of counsel in order to vindicate the Sixth Amendment right that attaches at trial. That due process right only exists in the first PCR, if it exists at all. Now, definitely there's a statutory right, but Justice McDonald, you asked where's the stopping point? How do you prevent it from being turtles all the way down, where we've got a seventh PCR application that asserts a constitutional right following on from all of the others? The stopping point is the first PCR has that due process right because of the Sixth Amendment right to effective assistance of counsel at the criminal trial, and then that PCR proceeding in which claims can be litigated and counsel can be appointed, that satisfies that due process interest. And after that, there is no constitutional right to post-conviction counsel or to a, there's a statutory right in Iowa, but there's no constitutional right to another forum in which to litigate and present evidence about the effectiveness of the assistance of post-conviction counsel in any prior proceedings. The only reason that ever existed, that constitutional right to do that in the first time, was to protect and vindicate the Sixth Amendment right. And you have to have enough process to do that. And the first PCR, exactly.
Are you saying in PCR 2, am I paraphrasing this correctly, that no lawyer, even Perry Mason, could have breathed life into a failure to hit a deadline? That it doesn't, that the attorney's actions or inactions aren't the problem? That it was I was trying to follow you on that, as if you said something about a motion to dismiss. It was a timeliness argument, correct? So then did it really matter?
This case is, well, I think that's true. I don't think there's anything in this record that could give anyone a reason to believe that there was a way around the time bar here. I also think that if there was, that's the applicant's burden to show. Now, I know that 814.7 I don't think applies on appeal from PCR actions, so you could decide a PCR, ineffective assistance of PCR claim on appeal from that PCR action if the record's sufficient. And this is another instance where preservation of error and creation of a record becomes absolutely essential. And I know that there's this, on PCR, it is fair to expect the applicant to take an active role in involvement with the claim, the litigation, to understand the claims that are being raised, and if they are dissatisfied with their attorney, to say so. And if they have concerns, to tell them to their attorney, and if not, then to tell the court. This is inherent in any action that contains, this is the case in civil litigation all the time, where clients have one shot and they need to work with their attorney, and what happens during that first proceeding is a preclusive adjudication of their rights and liabilities. And if there's disputes with counsel, those need to be explored. But what the applicant can't do is sit back, let it proceed.
Really, the applicant. I mean, it is. I think what Ms. Donels talks about. I mean, when I was in practice, I did federal work, 2254, 2255, and I assure you, I communicated with my client, but I was doing sort of a one-off, as a loss leader within my law firm. At these rates that the state pays, and it's not realistic to expect this level of communication between counsel and the client that you're talking about. And really, I think it has to be up to the counsel to get in touch with their client and start the chain of communication.
PCR, it makes a lot more sense to have much more communication where there's merits of claims to be litigated without a time bar. But I also think that if the applicant is dissatisfied with what's happening, they need to tell the court. Even
New statute. I used to get those all the time, and then they put that, and then after I came on this court, there's that new statute. But if they have an attorney appointed for them, they're supposed to stop this communicating with the court, which we all knew were 25-page handwritten single-space letters to the court by someone who was represented by an attorney.
my time's expired, but I thank you. So they can still tell the court that they're dissatisfied with counsel and need new counsel. They can also elect to represent themselves. They have ways to make sure that the claims that they care about are being raised. And the fact, I mean, no court has, to my knowledge, has found that a rule against hybrid representation violates any due process right or deprives the proceeding of preclusive value as to claims that could have been raised in that proceeding. So I think that that is, like the statute of limitations, a rule that limits how claims may be presented that still provides a reasonable opportunity to raise the claims. And if I could make one brief remark on the indigent defense issue, this case involves a really interesting marriage of two issues. On one hand is this request to adopt equitable tolling, which 822.3 specifically forbids, which would open floodgates to a whole bunch of new cumulative and time-barred PCR claims. On the other is this claim that PCR counsel are almost per se ineffective just because they have too many PCR claims to handle with the amount of them there are to take these cases. Any ruling in Mr. Ruiz's favor will exacerbate this problem. I think the way to make progress towards dealing with it is to adopt rules that don't lead to the proliferation of obviously meritless PCR claims on second and successive applications where, and I have to disagree, I don't think counsel can file an Anders brief when they think that there's no merits. I think Gamble prohibits that. It just leads to a situation where you're appointing PCR counsel to the same repeat filers on a 7th, 8th, Xth PCR application where, yeah, it increases the burden without any commensurate benefit and doesn't protect any real, definitely doesn't protect a statutory right and doesn't protect a constitutional right either. Thank you.
You come up here, I wanted you to address, we were talking earlier about what was or wasn't on the record. And the district court's order does say, having considered the arguments of counsel and the applicable law.
Yes, Your Honor. First of all, I think that's boilerplate language that appears at...
Says a former trial judge. I didn't put it in every order. If I didn't hear argument, I didn't say it.
Also says, having considered the arguments of counsel, which the plural and the singular form of counsel are identical. So I don't know if we can read that much into it, Judge. Whatever the arguments that Words here did or did not make, they're not contained in the order. We're asked to assume that she made arguments, but there's no evidence that she did. She asked to submit written briefing. That was in the order, and no written briefing was ever submitted. But I want to start where this left off, that any ruling in Mr. Ruiz's favor will make the indigent defense crisis worse. And I just don't see how that could possibly be true, because
Filings?
there would potentially be more filings, but there's no reason that we can't put harsh limits on these safety valves. Equitable tolling is a difficult burden to meet, but it's one that the federal courts have managed to handle, despite there being way fewer federal judges than there are state court judges. Allison did open the floodgates, but most of the claims were very quickly disposed of because it was easy to tell whether or not they were promptly filed. It'll be easy to tell whether or not litigants are diligently pursuing their rights and extraordinary circumstances stood in their way. Now, whether we're looking at this case through the framework this court set out in Allison or through the equitable tolling standard, Ruiz would meet it. He filed this petition 2 weeks after his first appeal was dismissed. If Allison were still good law, he would clearly fall into the prompt relation back doctrine.
opponent points out that the statute explicitly forbids an equitable tolling theory. Do we have to say that 822.3 is unconstitutional to find in your favor?
Legislature says things that are unconstitutional with some regularity, not just in Iowa, of course, everywhere. It's this court's job to look at the laws that are passed by the legislature, compare them to the Constitution, and decide whether or not it's good enough. Now, yes, yes, and Allison, this court talked at length about how important it was to have effective assistance of PCR counsel. The legislature said, no, thank you. I think that was a mistake. This issue has not been squarely before the court since that issue. In Sandoval, this court recognized that Allison was abrogated, but that was Mr. Sandoval's fourth PCR petition. There was no way that he would have promptly related back, and it wasn't presented in the briefs either.
It troubles me as a practical matter because I am sympathetic to some of what you say. I understand you can't say something that's not in the record, but if I were in your position, I might say, here's an argument that Mr. Ruiz might like to make or might want to make in order to set aside his conviction, because there's nothing in his pro se application, as Mr. Sloven points out. And so we're sort of being asked to, kind of upend some law, expand later or apply later or whatever, do something for the benefit of what might just be a pointless exercise.
Is a pro se petitioner who didn't go to law school and doesn't know how to read these statutes and how to present his claims. It's very common practices in these cases for the court to appoint counsel and order them to confer and file an amended complaint so that we can figure out what the heck these guys want. And that didn't even happen. There was no opportunity to amend the complaint to figure out what it was he was pursuing. And that was actually found to be structural denial in the Stetchen case, which is cited in the record, where the petitioner didn't actually file a PCR petition, but he filed an application for counsel to help him put a PCR petition into the record, and the court appointed counsel, and then the counsel didn't file a petition until after the statute of limitations had passed. That I do not know. It could have been a first PCR. But this brings us back again. I understand the court doesn't want this to go on forever and ever and ever, and that's reasonable. But there are procedures that can be put in place, like initial review, which is done in the federal courts. I assume it was still done when when Justice Mansfield was practicing, to see if there's
than we do. Yeah, I mean each trial judge has 3 law clerks, so it's a lot different. In
the federal system, yeah.
cut them down to 2, Justice, but
my wife was a clerk for a magistrate, and they do a lot of that work, and she ended up doing a lot of it.
and my time's about to expire. If it's okay.
Wrap up.
With, I thought it was counting down. I must be getting tired.
Question first. Justice McDonald.
This play out on a newly discovered evidence claim, which I think you say is his claim in this case, right? So that claim is not subject to the time bar.
Right. So if you could elaborate a little bit more on the hypothetical.
I mean, either he presented it in this case and we have no record of it and the district court just denied it. If he didn't present it in this case, he can still present it in a subsequent PCR that's not time barred, right?
He would need the assistance of counsel to explain why it's not time barred. That's why he asked for court-appointed counsel, and counsel did nothing. The resource issue
itself wouldn't necessarily apply if it was newly discovered evidence and under 822.8 he could explain why it wasn't presented earlier. He would still get a second or third crack on it in a case that might actually be more meritorious, that no other courts looked at because no other courts had the opportunity to look at the newly discovered evidence. So he still has avenues for relief potentially, correct?
Right, but none of those avenues relates to the ineffective assistance of trial counsel because of the way that the statute of limitations worked out in this case.
Here's the thing, though. That seems like 2 different arguments, to say counsel was ineffective and to say you have newly discovered evidence. Those usually are two different things, or newly, something that's newly discovered.
Preventing someone from raising them in the same petition, however. I guess,
Me, that Justice McDonald has a good point that, if we were to hurry up and affirm here, you could go out and file a third PCR and raise whatever this actual innocence, newly discovered evidence argument is, and be, as long as you're, I think, within 3 years of that reasonably having been discovered, you would be timely.
to conclude, I don't know who the court would appoint to represent Mr. Ruiz in that case, because Scott County no longer has a single contract attorney taking PCR cases. There is a resource problem. I don't want to ignore it. And I know that this court,
Case if we were to reverse?
the resource problem, that's why we're asking the court to look at Allison, to look at equitable tolling, because there has to be those safety valves. These problems are going to keep getting worse. This court has recognized in the past that it does have the power to help indigent defense. English v. Missildine was one example where this court recognized indigent defendants need resources to have competent counsel. And it's not just the defendants. This hurts the victims too. These cases will not have finality if we cannot be sure that they had effective assistance of counsel. So in conclusion, we'd ask that you remand this so that Mr. Ruiz gets a shot. Thank you.
Versus State of Iowa is hereby submitted, and court is adjourned for the afternoon.